We can get started, I think.
Yes.
Okay. Well, thank you for joining me. So it looks like we have a couple people here. Absolutely. So this is Infinite Monkey Selfies, Intellectual Property Protection and Generative Artificial Intelligence. This is a new talk that we're doing this year, and it's still in process. So there's still some rough edges around it. So we'll have some fun with it. My name is Fred Wilf. On the horn is Josh Waterston. He's the handsome guy, as opposed to me. And the two of us have contributed to the presentation. I'll do most of the talking initially, and then Josh will interrupt from time to time. All good. Let's see if we can get this to work. There we go. A brief overview. We're going to talk briefly about infinite monkey theorem, monkey selfies, generative AI, which we'll spend the least amount of time on because we're assuming that from the earlier talks, you know this already, and more importantly, you probably know far more about this than I do walking into the room. But we're focused in on what IP is, some of the cases and controversies, the frameworks, hypotheticals. I have right now 2 slides worth of references because this has gotten a lot of good attention, some thought behind it. We'll go from there. So let's start with the infinite monkey theorem. The infinite monkey theorem has evolved over time. It's been put in the context of several different approaches. One is that 1,000 monkeys on 1,000 typewriters, given enough time, will type all the works of Shakespeare or all of the books in the British Museum. Variations of this theorem have gone back, some people say, to Aristotle. They all explore the likelihood that we have an extremely large set of random actions within specific parameters. Those random actions will eventually create or reproduce something that is already known or is relatively familiar. It's usually not in the context of developing something completely brand new. And raises the questions, well, do the monkeys know what they are creating when we're trying to get them to create something that monkeys did not initially create? Are the monkeys responsible for what they are creating? And will humans recognize any rights of the monkeys to what they create? And that's really where the legal issue comes in. Who has what rights and who decides? Now, we have the monkey selfie example. A gentleman, a British photographer named David Slater, traveled to an island in Indonesia called Sulawesi, with his intent was to photograph the great apes on the island and to also raise knowledge about them among the general public. At one point, while getting to know them and them getting to know him, he set up a couple of cameras, set the cameras up on autofocus, auto exposure. The monkeys press the shutter button, and we got some really neat photographs. Mr. Slater then began to share those photographs, publish those photographs, make money from those photographs, and it kind of blew up in a bunch of ways, not including a couple of legal issues. And we'll get to those in a few minutes. On the AI side, again, I'm assuming that everybody who is watching this knows more about AI probably than I do already, which is that it has been with us for decades. A gazillion years ago, when I was in college and learning computer programming, I was reading about ELIZA and trying to teach a mini computer how to play Othello with a couple of levels of look ahead. And that was about the extent of AI back then in the late 70s. But then with ELIZA, there's some occasional reports of disturbing behavior. And more recently, with much more advanced AI, basically ELIZA's great-granddaughter, Sydney, we have some more recent reports of disturbing behavior. I'm not sure who's more disturbed, the AI or the people who are working with the AI, who are upset for one reason or another. Meanwhile, the various offices that take in applications related to intellectual property have been receiving applications that say that some contributor or another to a work, either a copyrightable work, which is usually an artistic work or other work, or to a patent application, was generated in part by an AI. Now, it's not by any means the first time that these offices have received claims that seem questionable. Throughout the term of the Copyright Office, which goes back now well over 100 years, there have been claims that somebody or something created something protectable under the law. At one point, there was a case where in the 90s, somebody claimed that some intergalactic beings from Urantia had invented or had written a book, essentially, that became the Book of Urantia, and that got some attention for about 5 minutes. So it's not the first time these claims have been made. It's not the first time that these offices have been seeing these claims. It's not the first time that these issues have come up. What's different here is that the AIs are much more advanced than they were. And unlike claims such as an intergalactic being creating something or some sort of higher authority, you can actually see and have some evidence of people interacting with something else and who owns and who controls that. So some background on IP, intellectual property. Now, and I'll keep this very, very short for what is still a very big area of law. And we use the term intellectual property to address this rather large area of law, but it's not really a single area of law. What it really is a category collection of related areas of the law, mostly focused on rights and intangible property. It's not a single area of law, it's not unified. Copyright law is different from patent law, which is different from trademark law, and so on. Each have their own history, each protect different things, each have their own rules and regulations, each protect some things very well, and some things just fall through the cracks. For example, if you're looking at a computer program, a piece of software may be protected by copyright to the extent that the text of the code is original and non-trivial. It may also be protected by patent to the extent that the code is an invention that is new, useful, not obvious to one skilled in the art. And yes, the code, if it's connected to some sort of service or good, can also, the name of which can be protected by a trademark. If you implement it in a semiconductor chip, you might actually have a mask work. Again, they protect different things, different areas of law protect different things. They have different issues to whether they can or should or need to be registered. If they are registered, if they are protected, the duration changes from one area of law to the other. We're going to spend more time on copyright law because there's been more cases in copyright law. And with copyright law, what we're looking at is a law that protects original expressions of ideas, but not the ideas themselves. You want to protect an idea, you can protect an idea as implemented using a patent, but you cannot, you're not protecting the idea under copyright law. If somebody's come up with a new way to program a particular device, that might be protectable by patent. If there's 20 different ways to program that device, each one of which is original and non-duplicative and non-trivial, each of those 20 implementations, each of those 20 programs, if you will each have its own copyright, as long as it's original, as long as it's not trivial, as long as it's not copied from somebody else. It's anything protected in the tangible medium of expression. We have some examples of works beyond software, including artwork, text, photography. So under the law, who owns a copyright? If it's, in many cases, if the person's not an employee, the copyright is initially owned by the creator. If you have an employment situation, you have a work for hire, definition number 1, which looks at anything created that's protectable by copyright. If it's within the scope of that person's employment, the employer automatically owns the copyrighted work. Some of that's not intuitive because people don't realize that you could be at home, working on your own computer, doing your own thing, not working for the employer. But if you build something that's protected by copyright within the scope of your employment, which is a big, messy term, the employer automatically owns that. Non-intuitive. That's definition number 1. Definition number 2 applies to independent contractors. It only applies to independent contractors who create works that fit into one of 9 categories. Also, one difference between definition 2 and definition number 1 is that you need to sign a document. The independent contractor needs to sign a document, preferably that has the magic words "work for hire" somewhere in the document. A third way to transfer a copyright from one person who owns it to somebody else is an assignment. That's a transfer document. Patents are different. Again, patents are a limited monopoly on ideas as implemented. And you can claim new and useful processes, machines, composition of matter, improvements, with the plants even. But you must show that the invention is new, it's not been done before, it's useful, and it's not obvious to one skilled in that art or technology. So let's look at some of the more recent examples of issues that have come up. First, let's start with Wikimedia. When photographer, Mr. Slater, came back from Indonesia, he made his photographs available. He claimed rights in those photographs. He sold those photographs. Wikimedia, which is the entity that runs Wikipedia, made copies of those photographs and made them available on the wikipedia.com website without paying Mr. Slater. Mr. Slater asked for some money. Wikimedia said no. And Wikimedia's approach was to say, we read how the photographs were made, because I had excerpted some language from what Mr. Slater's own webpage, talking about how the monkeys made the photographs. And the lawyers from Wikimedia said, well, as far as we're concerned, having read what the Copyright Office says, we think that the photographs are in the public domain, so no, Mr. Slater, we are not going to pay you. And they went back and forth a little bit, because after all, even before this erupted, the Copyright Office had said before that if it's not a human, we're not going to grant a copyright. Mr. Slater did not sue Wikimedia. Let's be clear about that. There was no lawsuit. No lawsuit. Now, Mr. Slater being based in the United Kingdom, there's some discussion back and forth with the IPO. Note you don't have copyright registration in the United Kingdom. That's mostly a US issue for copyright. And the very nice people at the UK IPO did ask the right question, which is it depends upon whether the photographer or the developer of the work, the creator of the work, has made a creative contribution to the work, and then he punted. So this is a decision which must be made by the courts. So the courts had one opportunity, a case called Naruto versus Slater, where apparently Naruto is the name that somebody gave
Fred just muted himself by accident. Can somebody reach him?
That was me. Sorry, guys. Fred, if you mind unmuting. Where's the background noise?
No problem. Can you hear me now?
Now you're good.
Okay.
Thanks.
Okay. Can you hear me without an echo? Apparently not.
There can only be one microphone in the room. I think that's the problem.
Fred, if you unmute an ITPC speaker is muted, then then we'll be able to hear you, or vice versa.
It was working before. What changed?
I am.
Okay, now.
If you mute the ITPC microphone, I think it will work. And turn Fred's one on.
Okay.
I think the answer is that ITPC needs to be unmuted. There's just going to be some background noise at points. Okay, Fred, this should work maybe? No.
Try it again.
Can you hear me now?
Yes.
There we go. Too many microphones.
Yeah. Too many buttons.
Okay,
Okay, keep going.
so we were with a case called Naruto versus Slater, where PETA filed a case as the next friend of the ape, of one of them. The trial court dismissed the case on the grounds that monkeys can't own copyrights and photos based on what the Copyright Office has said, and went up to Ninth Circuit. While the appeal was pending to the Ninth Circuit, Mr. Slater entered into an agreement with PETA and with some other entities to have the case dismissed. And then PETA and some of the other entities who were involved in the case asked the Ninth Circuit to vacate the lower court's opinion. The Ninth Circuit, being of an independent mind, said, we're not going to do any of that.
This is the Ninth Circuit.
This is the Ninth Circuit.
Know that they're independent minded.
They're very independent minded, always have been. And they said, well, it's nice that you came up with a settlement. It's wonderful that you think that the trial court opinions is not important, but we're not going to vacate that. We're also going to toss the case out on our own grounds, in addition to on the basis that PETA has not proven that it speaks for or is a next friend to any of the monkeys involved. So case dismissed, and we're not going to even get to any of the basic issues as to who owns the copyright, because it was brought by PETA on behalf of the monkey. The monkey the monkey may have constitutional standing. PETA has no standing on behalf of the monkey.
Right.
So if you find somebody who actually can say with a straight face and can prove that they are somehow connected to that monkey, maybe it's somebody in Indonesia, as an example, and nobody from Indonesia has come over apparently, then we can go back and look at that. So that was fascinating.
Was he still obliged to pay the part of the proceeds to the nonprofit?
Yeah, because he agreed in his settlement. It was basically a contract. So let's see back here. There we go. So next case is Zarya of the Dawn. Zarya of the Dawn. So Miss Cashnova apparently used an AI known as Midjourney to prepare much of the artwork that appeared in a comic book. Apparently, Mix Kashnova called it a comic book. Other people called it a graphic novel. Call it what you will. It was about 18 pages long. She designed it. Or perhaps she used they, them pronouns. So Mix Kashnova, they designed it. They wrote the text. They edited it, put it together, sent it in. Now, the funny thing is that even though it says on the front page, and you probably can't see it too well, it's too small, it lists both Kashnova's name and the term Midjourney as authors of the work on the front page. When Kashnova filed the copyright application, the only name that appeared on the application was Kashnova. And then in social media, Kashnova told everybody, oh, by the way, I used Midjourney for a lot of the artwork. And because it's social media, somehow it got around. The reporter called up the Copyright Office and said, we see that Kashnova is claiming that the Midjourney AI did most of the artwork with some cleanup by Mix Kashnova. What did you, the Copyright Office, think about this? And what they thought about it was to send a letter to Mix Kashnova saying, we've learned that an AI did most of your artwork. You have 30 days to tell us what really happened. And the registration we granted you, which begins with the VA for visual arts, VAU means visual arts unpublished, followed by the number. Give us an explanation. Kashnova's attorney, Van Lindbergh, sent a long response explaining how it worked. On review of that, the Copyright Office canceled the original registration and gave a new registration that exempted all the AI created work. If you are interested in this area and you have time, I do find that both the letters back and forth between the office and the council are pretty interesting because they provide more detail in how this is done and how the Copyright Office thinks. But what's very clear, though, that to the extent that parts of the work created by and contributed by the AI were created by the AI without a huge amount of input from Mix Kashnova, that was held not to be created by a human, and therefore not protectable because we're only going to protect human-created works. So that leads to, and beyond that, there's been a whole bunch of other cases, but I want to focus on some of the analysis here. So one copyright framework here is that AI technology is a monkey. If the contributions of the AI are simply independent of human contributions, if they are, they must be disclaimed as authorship to the extent that what the AI does itself is original and non-trivial. In that case, we will say that the AI technology is independent of the human, and therefore any contribution by the AI must be in the public domain. That's one framework. Another framework, which is hinted at in some of the back and forth between Kashnova's attorney and the Copyright Office, is that AI technology is autofocus. AI technology is a tool that is used by a human being to help out, but is not independent of the human. Just as you have in your smartphone, the smartphone camera can focus, the smartphone camera can find the right exposure without human intervention. That is considered an aid to the human who's creating the photograph and is not independent of the human. Certainly, the human contribution does not include the autofocus. The human contribution does not include the exposure level, but there's enough created by the human that these aids that are AI based to some extent or another are not sufficiently independent of the human that it deprives the human of authorship, of creativity. So in some cases, you can show that the AI technology is pretty much directed by or as an aid to the human. It's not independent of the human. It does not deprive the human of any contribution connected to that part of the AI. But the tool has to be somewhat limited. Finally, what I'm not seeing as much of, and which I think we'll be seeing some more of in terms of litigation, is that AI technology is a code library. Right now, if you have AIs being trained on large amounts of data, some of that data might be very focused, some of that data may not be very well focused. To the extent that the AI is programmed to learn from a particular set of data, and that data reflects human contributions, does that mean that the people who contributed to the learning are co-authors? Does it mean that the person who, or people who wrote the AI and taught the AI how to learn are also contributors? And we have a lot of discussion of that. We have, what is also interesting is we have some cases that I haven't mentioned here, which will be adding to the next version of this talk. There's been some discussion about databases, especially of artwork, suing AI owners for using their artwork without permission. And that some of the works have been clearly derived from recognizable artwork of third parties whose artwork is in the data. That includes, I think, from Discord, which was used, by the way, for Midjourney. That includes some artists who have written blogs about this and have seen artworks in their own style. And I expect we're going to be seeing some cases on that eventually. Now, of course, litigation is a very expensive game. It's not something you can do lightly. It's not something you can do for fun, unless you either have somebody who's willing to back you, because it's an important enough question and then they've got funding, or because they are they've got generational wealth that they're willing to burn. So it's common for these kind of issues to not get litigated. But I think we will see more back and forth, especially at the administrative level with the Copyright Office. I think we will see a couple of cases here and there, as some attorneys will take these cases on a flyer to get their name out. So let's talk a little bit about patents, because here we have an example of at least one gentleman who has been happy to fight the patent context. There's also been involved in the copyright context. There was an earlier copyright claim from, I think, 2022 involving this gentleman, Stephen Thaler, who filed both applications under patent and copyright using an AI that I believe Thaler created, called it, and I don't know if I'm pronouncing it correctly, DABUS or DABUS, which stands for Device, the Autonomous Bootstrapping of Unified Sentience. Great acronym. At least I hope he enjoys it as much as I do. So DABUS apparently has been used to create some artwork that was submitted to the Copyright Office, and the Copyright Office rejected and said, no, there's nothing here that we see that's human, therefore we'll reject it entirely. He also filed a couple of patent applications, and in the case of Thaler versus Hirschfeld, the trial court tossed it almost entirely on administrative grounds. All the documents from the patent office said, tell us who the inventor is. And Thaler said the inventor is an AI, and here's an assignment from the AI which I created to me as an individual. And for some reason, the judge was not amused and did not accept it. But it went, the case is interesting I think more to a lawyer than to anybody else, because it was stuck more in the context of here are the rules, here are the regulations, and we're not going to go beyond those. And the assignment from the AI called Davis to Mr. Thaler, that's signed by Mr. Thaler on behalf of the AI to Mr. Thaler individually, we're just not going to accept that.
The courts don't indulge in fantasy very often.
Well, actually, I wouldn't go that far, but no, they try not to. I agree with that entirely. They don't try to indulge in fantasy.
Yeah.
But that case is now on appeal to the Federal Circuit under the name of Thaler versus Vidal, because the name of the director of the patent office has changed from Hirschfeld to Vidal. So let's look at a couple of hypotheticals. One hypothetical: developer writes an AI, trains it on all the speeches of Winston Churchill. The user writes or asks the AI to write a speech about a current topic. And depending upon which variation of the approaches you use under copyright law, one approach could be that this is just a tool and the user owns the entire copyright. Another approach could be that the AI, having been sufficiently trained on the speeches of Churchill specifically, this may be a derivative work of Churchill. And finally, a third approach could be the developer who created the AI actually has a hand in this, and therefore this should be a shared work of the user, Churchill, and the person who developed the AI. Now, to the extent that Churchill has since passed on some time ago, and most of the speeches by Churchill may be in the public domain and some may not be, by the way, because copyright lasts a very long time. And Churchill, I don't think he passed away until around 1965. So many of the speeches are probably still protected by copyright law, although most of the ones probably pre-1920, they'd be in the public domain. But the more famous ones from which may or may not be in the public domain, or they could be under what is called a crown copyright, which is different in Britain, because some things created by the British government are owned by the crown. And I don't know enough, and I apologize, but I don't know enough about that area of copyright law as applied to the UK to be able to answer that question. Another hypothetical is the artwork hypothetical. Again, developer writes the AI, trains on the artwork of Pablo Picasso, which is substantial. Again, Picasso has since passed on. The user uses the AI to create artwork for a graphic novel in the style of Pablo Picasso. So are the authors the user, Picasso, the developer, or some combination of the above? And I don't have or public domain, because it's an AI, says the copyright office, and to the extent the AI created it and is independent of both Churchill and the developer, then it's in the public domain because no human wrote it. And finally, variation, which is much less focused. Developer creates the AI, trains it on the social media and all the social media feeds that the developer could find. It just threw in a very large number of inputs. And the user uses the AI to develop a graphic novel. Who owns that? And again, it could be the person who asked the AI, the user, could be the developer to the extent the developer has contributed by teaching the AI how to learn. Or are we punting by saying that we can't put our arms around all of social media and therefore it's too big of a thing? Or do we say that the development by the AI, again, is independent of human development and therefore is not protectable? I don't have a good answer for you today. I don't like some of the answers that I'm hearing. But I'm also not putting my money on any one of these particular approaches quite yet.
But suppose that Congress took action.
Ah,
They have the authority to set rules for this?
so yeah, if you didn't hear it, the Congress does have the right to set rules
Yeah.
about this.
Because the rules on copyrights and patents were set by Congress in accordance with the power given to them by the Constitution.
Exactly.
So they wouldn't be limited to say, oh, it's only humans. They could actually grant grade eight's photographic rights, or they could,
Absolutely.
or they could give stuff to Pablo Picasso that's errors, right?
Yeah. And several of the cases have said in the past that if Congress wanted an ape to own a copyright or an animal,
Yeah.
because it's not the first time an animal has created something, Congress could have said that, at least potentially, but it did not do so in this case. And the constitutional language, I believe, is that Congress has, and this is the so-called the copyright clause. Congress has the right to grant to creators the rights of their creation for limited periods of time. So, if a creator is an animal and Congress says an animal can own those rights, Congress might be able to give those rights to the animals. I don't see why not in that case. Now, we're still going to end up with the courts, even in that case, arguing over whether or not, from a constitutional standpoint, that's enforceable or not. But that's the fun part. So I don't know. It'd also be interesting to see what other countries end up doing.
Yeah.
And so far, the issue has not been raised in many other countries. Let's see right here. So I actually also have 2 pages of references here. So anybody who has a copy of the slides, I'll be happy to give them out. And we'll be updating the slides over the next couple of weeks, Josh and I, until our next talk. And one of the things we'll be adding, Josh was kind enough to go to Midjourney, the AI, and ask for monkey selfies. And let me see if I can stop sharing here and find examples of those monkey selfies.
I think you may have it. I don't know if anyone can hear me.
We can hear you.
We can hear you.
All right. I have, I can actually maybe answer the Pablo Picasso question. I was just on Midjourney and I did a prompt which was painting in the style of Pablo Picasso. And let's see if I can get it. Hold on. It may require that people log in here. Let me see if I can.
First, let me show. I'll first show them the monkey selfie ones that you did.
Nice.
Okay, hold on. Let me get back to where I was. There, and share that. So you should be able to see that.
Oh, wow.
So these are monkey selfies.
Oh, Fred, we can see your email. Probably want to stop that. There you go.
Don't stop that share. Never mind.
I saw.
We're focusing on the monkeys.
We're looking only at the monkey selfies.
We're not reading.
So, questions. I don't know, Josh, can you
You should be
share?
able to share. I made him a co-host.
Yeah, here we go.
Okay,
If I can, I don't know. Am I allowed to share my screen? Will that cause any issues?
Yeah.
try it.
All right, it'll just be.
There you
Oh,
go.
there you go.
Yeah, we see it.
So it's painting in the style of Picasso, and I mean, what was it trained on? It had to be trained on Picasso paintings. I mean, how did it get these images?
Yeah, and what I find interesting is that it looks like, again, I'm no expert, but it looks like an amalgam of different Picasso approaches over the years. Because
Absolutely.
every single one of them is blue, which
His blue period.
Has
He
the inference.
stopped doing it like 1906.
Yes, so he stopped doing a blue period in 1906. So you have some older Picasso, you have some newer Picasso. You don't have a purely it's still representative to a certain extent. Yeah, it's Picasso-like. Picasso-like.
I mean, maybe the lower left one is probably.
That looks like it's supposedly based on an image of Pablo Picasso in
Right.
the style of Pablo Picasso.
Yeah, it's a self-portrait by the AI.
Right.
If the AI was wearing a Picasso mask, it would look like that.
Right.
Yeah. So I guess my point is that, and I saw one online. By the way, Fred, I was doing very important legal work as well today, just so you know.
You don't have to. Let's focus on the topic.
As everybody knows, no. I saw one which was Groot in a kitchen. That was the prompt. So it's a picture of Groot, the Marvel character, the Marvel Comics character. And it's obviously that character, which is owned by Marvel.
Right. Which brings up trademark issues too.
Yeah.
Great. When I see Enzo has his hand up. Enzo?
Mhm. I have some hypothetical questions. Let me at least ask one. Aren't they all hypothetical? Well, I was looking at that Picasso and thing crossed my mind. Say I were to do something like that, or say I build the eye. I'm not in the field, by the way, and train it to make a music similar to Taylor Swift or some of the other, and then I present it, and nobody said, wouldn't be I coming very close, if not into copyright violation, right?
Yeah.
Which leads me to the one about trade secret. I think that's the legal, because I forget the legal term. Well, the other protections, there is the one often not talk about, which is you don't do the patent, you don't go about, you just keep it your secret.
Right.
Because one of the things with AI actually is very conducive to this is if I build a good AI and I have a competitive advantage, I keep it like a trade secret. So under some of those frameworks, I don't know what happens, because how can you tell that I did not create a work of art which is truly original? It was created by AI. Last but not least, there is the last thing I don't want to say. One of those frameworks caused me some trouble. I don't remember the name, because I'm thinking, well, if you got the AI like a tool, and it say that it's in one of the frameworks like AI has some rights on their own, right? And I actually can see sometimes evolving in that direction as we get closer to sentience. But let's say I'm using Adobe Illustrator or something. I don't know the software. I use Paint. I'm a very basic guy, right? And now you can make the argument and say, oh, that was assisted by the machine. Just because you're assisted by the machine, implies it's hard to tell where is you put the line of the creativity. And I like that the idea of you didn't mention more sweat, but there has to be an effort, the creative. You have to put some creative sweat into it. So
Well, it can
I
be-
don't have a question. Just elaborate on all the word salad that I gave to you.
Yeah, no, it's all good. A couple points there. One is the level of work and the actual way that the law looks at what's required changes from area of law to area of law. So in copyright, what they say is it has to be original expression, more than non-trivial. So it can be a very small level, they even use the word modicum, a very small amount of originality, but it has to be at least a small amount of originality in order to have it protected by copyright. So they're not looking for a whole lot there. It just has to be original to you, it's more than non-trivial. By contrast with patent, you're showing that this new invention you've created is new, useful, not obvious to one skilled in that art or science. That last one is a lot harder to prove, because you have to show that given all of what we know in humanity, you have come up with something that's a little bit better, a little bit smarter, a little bit faster, what have you. It is a step beyond, even if it's a small step, even if it's again, standing on the shoulders of somebody else. But if it's a small step above and beyond what exists, then that's a patent. And copyright, it can be a new implementation of something that you already have 1,000 implementations of. But if it's original to you, and it's only a slight amount of originality. Now, one thing that is not true, by the way, is we don't care how hard you work. One of the theories in the past with copyright was called sweat of the brow, that just by spending time doing work and it looks copyrightable, then it is copyrightable. That ended up in a couple of cases involving telephone books, telephone directories back in the day. Of course, we don't need telephone directories as much. We have the databases, but these are the hard copy telephone directories from the past. A white page directory that is takes a lot of work to put together, and which is organized by last name, comma, first name within a geographic area. That went up all the way to U.S. Supreme Court, the case called Feist versus Rural Telephone. And the Supreme Court held that even though it was a lot of work to put that together, it is not sufficiently original. And copyright will not protect it. So sweat of the brow as a way to have something protected by copyright no longer exists. But we don't care how much work you do or don't do. We don't care how much, how much you sweat to build this thing.
Yeah.
It has to be original and has to be non-trivial, and it can't be a copy of somebody else's work. That's what we're looking for. So now that is another reason why we go back on the AI side and back to Josh's Pablo Picasso version and the hypotheticals we were talking about earlier. If the AI does copy somebody else's work or somebody else's style, but we're right now in the context of the Copyright Office says if it's created by AI independently, then the work is public domain. Who gets sued by Picasso's estate, which has a lot of money and can burn lots of money for litigation? Meanwhile, I know all the litigators who would love to do this work. They're saying, "Ooh, call me." They're looking for this work, but I don't have an answer for that. I think it's a great question, and I think we'll be seeing some more of that going forward.
Fred, I had an idea.
Please.
I think instead of having one of the typical litigators represent the claimant, I think ChatGPT should do it.
There you go. I like
So
that.
That's just a thought.
Yeah.
So 2 birds with 1 stone.
There's actually Josh is referring to a recent case where somebody who has been selling AIs involving the law was saying that they would go out and defend a case involving a speeder or some other summary offense, some other basic offense. At which point the local bar association threatened to remove his license to practice. The attorney who was saying that the AI would do that has removed that offer, has retracted that offer. But we'll see if it comes back one way or another. But I mean, certainly we do see that AI is being offered up to attorneys and to non-attorneys as an alternative to lawyers. So we're not there yet, perhaps, but maybe sooner rather than later. We'll see, depending upon the work we do. Given that a lot of what what lawyers did when I started back when dinosaurs roamed the earth is no longer part of a lawyer's practice. I certainly can see AI picking up some of that as well, because the practice itself can change. So, other questions, comments? No?
Fred? Hi, Fred.
Yes, Lillian?
Could you speak a little bit on the nuances of abandonment for some of the copyright work? Let's say if someone state, I no longer want to do, I make some amazing drawing and then I decide, I don't care about them. Anyone can use them. I don't care. Now, can someone use AI and pick that up to create things? Or like, how does the abandonment aspect of it play in the whole copyright world? I know in patents that's one of the defenses that can be used.
Yeah, you have abandonment in patents, you have abandonment in trademarks as well. Trademarks is even stronger because a trademark, you have to continue to promote your brand in order to keep the trademark active and enforceable. In patents, you have to do some things to enforce your patent in order to avoid abandonment of the patent. Certainly beyond just paying the renewal fees during the term of the patent. Copyright is actually harder to abandon a work. The few courts I've looked at it say that an abandonment must be express and it must be very clear without any confusion. So if an artist has created a work, whether it's a drawing, whether it's music, whatever, and has posted on the website, by the way, all of this work that I've created under this name from this date to that date, I'm dedicating all of it to the public domain. That'll be enforceable as an abandonment of the copyright, or it's more specifically a dedication of that copyrighted work to the public domain. Public domain means that anybody can do anything with it. And once it's fully dedicated, it can't be brought back in again. It stays in public domain, at least that version of it. But because once it's dedicated to public domain, it doesn't come back. And also given that copyright lasts a very long time for an individual, again, an individual developer, creator, author, it's the life of that author plus 70 years. The courts have been very clear that it has to be expressed. So if an artist has stopped selling something and is no longer busy doing artwork, has gone in to do other things. In fact, one of the articles about David Slater, the gentleman who's set up the cameras for the monkey selfies, at one point he was thinking of giving up photography and becoming a dog walker because he thought he could make more money at that than at being a photographer. That probably would not be deemed an abandonment, even if he walked away from the profession. There'd have to be an express abandonment of those works, and then anybody can pick it up.
That's good. Thank you.
So it is different. I see we're at 5 o'clock, so 5 o'clock Eastern. So we're going to stop this, and I'm going to thank everybody for attending. And for those who've been kind enough to be here all day, thank you for being here all day. I appreciate it, and see you next year. And bring your monkey selfies next year.
Love yourself.